South Africa's laws do not just appear out of nowhere. They begin as bills before they go through the lawmaking process to become acts. So, a bill is the draft version of a law before it goes through the lawmaking process. A bill may propose either an entirely new law, it may propose a change to an existing law, or it can simply cancel an existing law. A bill must be drafted and formally submitted to either the National Assembly, the National Council of Provinces, a provincial legislature, or a municipal council before they can consider making it into a law. However, only a minister, a deputy minister, a portfolio committee, or a member of parliament may introduce a bill in the National Assembly. Likewise, only a member of the National Council of Provinces or a committee of the NCOP may introduce a bill in the council. The process of making a law sometimes begins with a discussion document called a green paper, which is often drafted by a government department or a ministerial office. The green paper deals with a particular issue, showing that department or ministry's policy position on the matter. The green paper is then published so that any member of the public interested in it can provide comments, suggestions, and ideas. So you have an opportunity to make your voice heard in the very early stages of a bill's formation. The green paper is sometimes followed by a more refined discussion document called a white paper, which is a broad statement of government policy on the issue. Comments may again be invited from interested parties and members of the public. During this process, various stakeholders, including experts and ordinary citizens, might propose amendments or other changes. Once comments have been considered and finalized, the relevant department submits a cabinet memorandum asking for cabinet approval for the introduction of the bill in Parliament. But before the bill can be formally submitted to Parliament, the state law advisors must certify it. The role of the state law advisors is to ensure that the draft law aligns with existing law and with the provisions of the Constitution. If the state law advisors are satisfied that the bill is technically correct and that its provisions are legally sound, they certify it for formal submission to Parliament. Sections 73 and 119 of the Constitution also grant members of Parliament, members of provincial legislatures and committees the power to initiate bills. Bills that are drafted by individual members of Parliament are called private members' bills. These bills usually address specific matters of interest to particular constituencies. The drafting and the certification of private members' bills is done by the parliamentary legal advisors, not the state law advisors. And the National Cabinet has no role in this process. Input is required from any department or organ of the state that could be affected by the proposed private members' bill, as the relevant parliamentary committee would need to discuss these inputs. When an MP initiating the bill briefs the committee, they must inform it of the date on which the bill was published and attach a memorandum explaining the bill. The MP must also state if they have received any public inputs, which must be presented to the committee, as these inputs would also inform the committee's decision. The committee must consider whether the member's bill is necessary. This includes discussing the member's briefing, the principle and the subject of the bill, and considering the public comments received. If the principles and the needs of the bill are accepted, the committee can proceed to deliberate on the details of the bill's registration for processing. In the next lesson, we'll talk about how committees can draft laws and shape legislation in the National Assembly.